Well, good morning, everyone, and welcome to the Public Safety Committee work session of Friday, April 17th, 2026. Today we have one topic on the agenda, Bill 526, Police Mask or Facial Coverings Prohibited. It's also called the Unmasked ICE Act. As we begin, I'd like to thank Ms. McCartney Green for preparing the staff report for the topic today, and for once again and always assembling most informative packets for us. Unless the other committee members have any or any of the visiting council members have any opening comments, I'm going to ask Ms. McCartney Green to lead us through, and I don't know if anybody else wants to come forward and sit on the panel. I can see that you maybe want to. Yeah. Rock, paper, scissors. Now I want to know how well you did on it. Does anybody have any opening comments? No. Could you do? Yes. No, okay. Could Earl and Chief?
Earl Stoddard, Assistant Chief Administrative Officer.
Good morning. Sorry. Darren Frank, Chief of Patrol, Montgomery County Police.
Okay, very good. And Ms. McCartney Green, please.
Good morning. Yes, it's Friday, so I had to double check.
Yes, it's been that kind of week.
Yeah. Oh, to say the least.
As mentioned before the committee, today's Bill 526, Mask or Facial Coverings Prohibited, the Unmasked Act. The bill would seek to prohibit federal, state, or local law enforcement agencies from wearing masks or facial covers while on duty. There was a public hearing that was held on March 3rd, and the council received about 20 speakers that overwhelmingly spoke in support of the bill. And we also receive numerous testimonies from individuals that supported the bill because, in part, fear caused by the presence of masked federal officers and the fact that the bill would enhance community members' ability to quickly identify whether someone is a Montgomery County Police or federal agent. The exceptions that are provided in the bill, and I'll just kind of go through them so that we're all on the same page, but some of the exceptions that are allowed under the bill is a medical grade mask that are a surgical or N95 respirator designed to prevent disease or transmission of airborne disease, masks designed to protect against exposure or smoke during a fire, masks that are necessary to perform duties during a water rescue option, and a mask related to exposure to biological or chemical agents during an incident where such agents may be present. And also a mask to be worn from exposure to cold during a declared weather emergency. And there is a special exception there for a SWAT team that use masks during the course of their duty. In terms of the impact statements, they did not expect many impacts for fiscal, economic, or climate, and the racial equity and social justice did say that it would have a positive impact in the county. Just a little bit of background. This has been well talked about in the news and the media, but I do want to just shed some light to active litigation that's in California. Very briefly, state of California enacted a mask ban, which they Senate Bill 627. It's called the No Secret Police Act back in September, which would also do the same thing similar to this bill in terms of prohibiting law enforcement officers, federal, out-of-state, and local police. The bill was challenged. United States government challenged the bill on a few issues. Some were constitutional and related to the Supremacy Act. The decision in that case was to the court ruled that there. I'm sorry, I misspoke. But the court ruled that there was a discrimination because this did not apply to state California police officers. There was also another act that was passed, the Vigilante Act, and that required federal officers to visually display IDs while on duty. Also argued for some of the same constitutional reasons. I will say that the court had a split decision concerning these acts. As it relates to the mask ban, there was a preliminary injunction that was issued to prevent California, because as I mentioned, it didn't apply fairly to all officers. And for the Vigilante Act, the court did hold that the officers did allow it to go in effect because it was considered less intrusive and did not significantly interfere with federal duties. However, there was later on a preliminary injunction also on that, so that's also not officially in effect. Just thought that was important because that is the most active litigation that's going on concerning the issue. In terms of bringing it back home to Maryland, Prince George's County has enacted a ban, and that went into an act earlier this month, and Baltimore County did not move forward with their legislation on that. So with that, I can go into the discussion part on page 4, unless the chair had anything specific about the background.
Okay. Go.
Okay.
Good.
And so what's more relevant here today is Senate Bill 1 that was recently passed in the Maryland General Assembly. It's a public safety law enforcement officers prohibition on facial coverings. It also has the same ban against federal, state, and local officers. One of the things I want to make sure that we're clear, even though the Maryland General Assembly passed that bill, it has not been signed by the governor. So there's a presumption making in some of the discussion here that if that bill is signed, that some of the related amendments would take effect. One of the bigger discussion that came out of Senate Bill 1 was that there was a express preemption language that was adopted through the House Judiciary Committee, and there was some concern of what impact that would have. Really what's relevant is the fact that the Senate Bill 1 not only has the ban and required that the Maryland Police Training and Standards Commission develop a uniform policy, and also require display of identification during the course of duty, but that would not go into effect until October 1st, 2026. And so with that in a nutshell, that just gives you the status and the overlaying background of Senate Bill 1. Any questions there, or can we move on to number 2?
All right. I think we're all familiar with.
Really,
Very familiar with all this.
Councilmember Jawando, I know, had an amendment that was related in terms of the passage of Senate Bill 1 and where Council Bill 526 would stand in terms of how those would interact.
Yeah, go ahead, please.
Thank you, Mr. Chair, and thank you for holding this meeting. I appreciate the Public Safety Committee, of which I'm a frequent member, an adjunct member over the years. And
Number 4.
yeah, appreciate Ms. McCartney Green, and to our Assistant Chief Administrative Officer and Assistant Chief. Thank you all for being here. So this amendment would seek to align with the Senate and House passed bill that has not been signed yet, but assuming the governor does sign the bill, this would sunset the bill upon the release of the uniform policy issued by the Public Safety Training and Standards Commission. And that would deal with the preemption issues and also align us with state law, but also allow for us to have this on the books here in Montgomery County until that time comes. That at a minimum, that would be October 1, but knowing the history of the Standards Commission, that I think it's going to stretch well beyond that into, potentially a year or more. And so I think it's important that we put this in place. And so that is what that amendment would do.
Anybody else have any comment on this? Or? Can we double check, and I appreciate what Councilmember Jawando was suggesting. I think we do obviously need to have a sunset on this when the state kicks in, and we certainly can't violate the state law. But can we double check what October 1st means on this? I mean, it doesn't say, and I have read this bill many more times, and I guess we all have, and it's the unusual rather than reading it this many times, but it doesn't say that they have to after October 1st. It says that we're preempted, but it doesn't say what happens after October 1st when we can no longer do anything. So if you could double check that. Please, go ahead.
So, and this is just because I know everyone's trying to decipher what this means right now, right? And the amendment as proposed by Councilmember Jawando related to the sunset is not keyed to the October 1st effective date of the legislation. It is keyed to when the policy is issued by the Maryland Police Training and Standards Commission. So it doesn't have a fixed date in the sunsetting provision. It simply means that unless and until the state issues its policy, this law will remain in effect. So I appreciate what the chair was asking about what does October 1st mean. I also don't know that October 1st as a date, and since it's not referenced in the amendment as proposed, is significant one way or the other, because the way the remainder of the House or Senate Bill 1 reads requires that things don't really happen until after the Police Standards Training Commission, I used to use the acronyms all the time, adopts its policy. And I just wanted to, is that where your understanding is presently?
What I was getting from the chair was whether or not the police training standards had to adopt standards by October 1st?
No,
Or-
what
No.
I'm asking is when we can no longer have our own policy. If they can, if it's, we know that October 1st, we could have something before October 1st, there's no question.
Right.
But what I'm asking is after October 1st, are we allowed to wait for the Maryland Police Training
Right.
and Standards Commission to come back? Or can we continue with their policy until, until then?
Right, because the express preemption language
Yeah.
doesn't have a trigger of the adoption of the policy. It's just there.
And so we're not talking about the policy, we're talking about the express preemption, and whether as of
Correct.
October
Yes.
1st, are we preempted and can no longer occupy or
Correct.
regulate in this field? I don't understand.
I mean, I'm in agreement with the sunset. The question is, when does the sunset
Agree.
take place?
And if legally it must sunset because of preemption, and that has a hard and fast deadline of October 1st, that's a separate issue. And, presumably we could do corrective, a housekeeping bill at that time, should that ultimately be the position of the state and upon further discussion, and then we can do a separate corrective bill to strike at that time.
Okay.
And maybe, and maybe by the time this goes to, in a couple of weeks, or when it goes to full council, we might even have that answer if you can get something informal. Please, I interrupted you.
I agree with Councilmember Lukey that if needed, we could come back as necessary. But as I look at it, I'm comfortable with the language here because from where I sit, our goal as a county would be to cover that gap between now and when we do have a state policy that's in place. That would be our goal. And so I think that using this language, my hope would be that we could certainly make a strong argument that that's what it does, and that's what we are able to do, given that the state bill, again, specifically cites the development of the policy by the commission. And I think it's much more likely that we're going to have a longer span of time between October, realistically, and when there really is a policy from the commission that's ready for us to adopt than between now and October. So I think it's important that we make sure that we do everything we can to make sure that our policy here covers that time period. And, ultimately the question is, if we made that argument that we pass this bill and we believe that that this policy, that we are covered until we have a state policy, if we make that argument as a county, is the state going to come after us and say, hey, we don't want you to have that in place, you need to do something about that? That seems highly unlikely, given that their goal is for the whole state, for everybody to have a policy, and their goal is also for it to not conflict with their policy. So I think there is I think it's very unlikely that anybody would give us a problem if we made the argument that our policy would cover us until the state policy is available to us. And I see Dr. Stoddard reaching.
Yeah, I'm not a lawyer. I know several of you are, but I did consult with the county attorney's office about this matter yesterday because obviously we were interested in the same question, and their interpretation is the same. That is, that any local effort or policy, even if we had a policy, would remain in effect until the uniform policy were issued, and we would have to then adopt a policy consistent with the uniform policy. And so, and having spoken to Ms. Roberts, the county attorney's office, who also sits and acts as the advisor to the state coalition for police chiefs, and often works on these matters as a part of the subcommittee at the Maryland Police Training and Standards Commission, her anticipation is this process could take months from October 1st, certainly. And if we, obviously they were involved in some of the regulations associated with the Police Accountability Act, and that was over a year, I believe, of of efforts. And so I would anticipate there's a lot of back and forth on this particular issue, and trying to make sure that every possible consideration is thought through with regard to, are there niche things where you might believe a mask was appropriate for a law enforcement officer, and they'll want to make sure a policy can cover those sort of unanticipated types of incidents.
Great.
And I'm comfortable with this, if this is allowed, and I believe what we've just heard is there are people that believe it's allowed, but Councilmember Joando many times says that this is just an opinion rather than, and so I think we need to make sure, just to double check, we don't want to violate our friends from the state of Maryland. So I'm good on this as it is. Are we okay on this as 3-0? Okay. With all of those, can we check, please? Okay?
Noted. Moving on to page 5, number 3 in the discussion. One of the things that the state bill also did was amend the bill to include requirements for identification. And I believe that there's an amendment here by Councilmember Joando, but just wanted to talk generally what's required from a police officer in uniform. I know there's certain regulations. The conversation is talking about local police, but we understand that the bill is applying not only to local, but for state, or the identification piece is applying not only to local police, but also for state and federal. So just didn't know if MCPD or if the chair wanted to hear just generally what's required for a uniform, and are there existing requirements and anything else to account for?
Okay. Did you want to, any other comment?
I can just tee it up.
Yeah, okay, please.
Sure. I know our police do wear identification, which I think that's what Ms. McCartney Green was fishing for there in the state of Maryland as well. And so this amendment would just align with the state bill to in anticipation, so we're even more in alignment with their policy that requiring a uniformed officer to display proper identification, provide the following the name, ID number, and the name of the law enforcement agency that they're representing, in that's obviously already required under state law.
Yep.
So this amendment would require an officer to wear an identification on the outermost layer of clothing while in performance of duty. Again, we're already in compliance, but this is obviously to go at the federal law enforcement issue. And so you can read the amendment, but it's in there. It just says law enforcement officer must wear identification on the outermost layer of clothing while performance of duty in the county. On a request of another, a law enforcement officer must verbally disclose identification while in performance and duty in the county. And then there's an exception that does not apply to law enforcement working in plainclothes, non-uniform, or undercover capacity.
Go ahead.
So I appreciate the effort to try to align it to state law, but it already exists. And so having this locally and putting this in our local law doesn't change anything at all. And I'm not just talking about with respect to our department, but the state law and the criminal procedure article cited in here, along with everything that's in the public safety article and in COMAR, and that the state sets for regulation of, it's not just state police, it is for all law enforcement that are state, county, or municipal in the state of Maryland. That this doesn't get us anything that we don't already have in state law. And because of the constitutional issues with respect to applicability to a federal officer, I don't know, there isn't an effect that it will have, because we don't have the ability to mandate what any federal officer, whether it's ICE or anyone else, has on their uniform or person in the performance of their duties. That is all specified separately in federal law. So could you speak to that, Ms. McCartney Green?
No, that's correct. I mean, as mentioned, state law and even our regulations does identify what needs to be worn by an officer. I believe this amendment here, and correct me, Councilmember Joando, is that the reach here is not necessarily just for local, or state, but it's for state and federal. And the only reason why this would be relevant later on is when we come to the enforcement procedures. So if there is a federal agent that's not wearing their ID, That's where this would have teeth. I'm not sure if that's the approach that we are,
Right.
but that's my understanding, is that putting this in here gives the authority that if they're not wearing it, some of the enforcement process could come into play.
Yeah.
There's a separate discussion on whether we can do that.
Right, because they're inherently intertwined, right? The what enforcement, if anything, is possible, and I understand the chair has amendments proposed as well that deal with this in a slightly different way, so that we collectively all understand the problem. Nobody wants masked federal agents running amok.
Or anybody else.
Or anybody else, frankly. But yes, I mean, the inherent problem is that this has been able to happen in other places and here, and we haven't had a way of managing it. But there is a problem that we have in the managing of it, in that we can only do what we are allowed to do. Right. And that is inherently the tension in trying to manage the situation. And so, I don't know if we want to hold on this amendment pending the discussion of the chair's amendment, but one of the things that we need to figure out is, what can we do? How do we document what is happening and make record of it, and what could be done with it? Because I don't know that, we're going to get into prosecuting federal agents when we have no authority to do so.
Will, and then
Yeah, sure. Thank you. I appreciate the comments, and obviously we're in uncomfortably difficult time right now, where I never thought we would have to be proposing to tell federal law enforcement what they shouldn't do here, but they're violating the rights of our residents. And as was mentioned by Ms. McCartney Green, I do think there is a gray area here on the federalism issue and on the Supremacy Clause issue. The court in California, which is the only federal court to speak to this, has said the reason that has said, the judge in that opinion said, you don't need to wear masks to do your duties. And in her view was that it wasn't a undue burden to tell federal law enforcement, that they can't wear masks in a state, or in the case of LA County, who both passed bills. The injunction was done because they said it didn't apply equally to federal, state, and local. That was the reasoning. This bill does, the state bill does. And so now, does that get overturned? Does it go to the Ninth Circuit and get overturned? Does ours get challenged and go to the Fourth Circuit? It will work its way through the courts, but I feel there's no settled law on that right now. And that's the bill in general. And I think this would be very similar in that the Vigilante Act, which Ms. McCartney Green was related to the ID, was initially upheld, but now is also being challenged. If you can tell them they can't wear a mask, you can certainly tell them they have to wear a badge of ID. I don't think one is more intrusive than the other. And so I think it is important to keep in for the reason of transparency and the underlying reasons of the bill, but also so that we align with the state bill. And that my hope is that we won't, at the end of the day, we don't even have to change our law because we're aligned with the state policy. So, and the third reason would be the connection to the enforcement. And we'll talk about that later, but I do think that's why you need this as well.
I think to the point that you said that we would not have to change our law to align with the state, I don't believe our law will continue or could continue after the state does what they're doing.
I meant to say policy, I'm sorry. But yes, it would sunset under the First Amendment.
Right, yeah.
Immediately already.
Yeah,
So,
yeah,
yes, so,
just
yeah,
wanted to
yeah,
correct.
yeah.
Please.
Thank you. I mean, to my understanding, this is basically the same question that we would have about the masking part of this. And so, which I think we're moving forward, hopefully, with that. Or that's my hope. And so to add this, I think makes a lot of sense. The same questions are going to remain, and we will see how that plays out. But the state bill does call for the commission to have as part of the policy that they're developing, as Councilmember Duando noted, this is part of that. So given that we are trying to be responsive to that, I think that it certainly make sense for us to include that. I'm comfortable with that. And that's something that has also been requested by members of the public over the course of the public hearing and otherwise.
Go ahead.
Yeah, I'm fine with moving the amendment forward, but I just want to be clear because I get that members of the public have been asking for this. But it's incumbent upon us to explain to members of the public that this is already the law in Maryland, even before Senate Bill 1. So the language that is in there with respect to identification is aimed at federal law enforcement agents, because Maryland already had law about this, and Maryland officers were already required to have their identification and a badge number, and et cetera. And so, Assistant Chief Frank, can you speak to that?
Sure, council member. Again, when we go back to the Police Accountability Act,
Right.
and Montgomery County's leadership in meeting all of the requirements, over 400 requirements between reimagining policing, between the Police Accountability Act, we put all of those in place. We operate consistent with the law. Our policies match the law, and most importantly, our officers have adapted and abided by the law consistently. Yes, it is focused at federal agents because Montgomery County Police already do this.
And I just wanted to make that clear, because this is not creating a new requirement for you all, or, and we as a legislative body only have authority really to legislate what happens with MCPD. We don't have authority to legislate any of our municipal departments, nothing at the state, and definitely nothing at the federal level. So we are signaling, that is what it is, signaling what we wish could be, but we actually do not have authority to legislate in that space. And while I understand and appreciate the California decision and the two different aspects of that decision, fundamentally that was a state law, and they did exempt the state police. I don't know why they chose to do that. They did. Nevertheless, the state, just like here in the state of Maryland, has the authority to regulate and legislate related to all law enforcement, state, local, municipal. We, as a local legislative body, do not possess that authority. So we are doubly down the path of distance from being able to take action with respect to that. So it doesn't hurt anything to have this there, but I felt the need to be really, really clear that our officers already do this, not just here in Montgomery County through MCPD, but other officers who are municipal partners in Rockville and Gaithersburg and Tacoma Park and Chevy Chase, et cetera, because this was already required by the state of Maryland. So with that, I think we're at 3-0.
I agree with it. I think that in order to go forward, I have no problem taking this to the full council with this amendment. I think that I agree. I think that it's belt and suspenders in many ways, but sometimes that's not a bad thing. So anyhow, I'm fine with this amendment as well. So it's a 3-0. I think I had a feeling that was going to be a 3-0. Okay.
Just want to clarify, do we still want this discussed at full council, or is it 3-0?
It's 3-0.
Okay.
Yeah, but everything's going to come to full council.
Thanks for the heads up.
Yeah, and what we've learned. Yeah, go ahead.
Thank you, Mr. Chair. And then there's one more amendment that I have proposed around enforcement, and I know it relates, and I want to thank you for your amendment as well. And I'll say at the front, I see these as complementary, and as opposed to one or the other. I think you can do both, but we'll talk about that. I see you nodding no. Okay, maybe you can. Okay. Well, I think you could do the ideas of both. Maybe
but you gave her a compliment.
Maybe the way. Well, so what this would propose, again, to help align with the county bill, but also set appropriate, with the state bill, but set appropriate levels of enforcement. This would, Ms. McCartney Green, what page is that on? I'm sorry, I was trying to. Okay, page 6 here.
Five.
Thank you. This would alter the process for a law enforcement officer who violates the mask ban by invoking our authority under county code to issue citations. And that is on Circle 25, and I'll read the actual language just to be clear on this. Once I get there. Okay. So this would, under Section 118, an enforcement officer may issue a civil citation to a law enforcement officer whom the enforcement officer believes is committing or has committed a violation of county law. The county code may enforce this section under 118 of the county code, and the fine and penalty of an officer who violates this provision, again, this is for federal, state, or local, or fails to comply with any of the requirements, will be subject to a Class A violation, which is in county code, and I believe that's do you know the amount of that fine?
Yeah, it's a $500 fine.
$500
yes.
fine. And then it also, there's a third section that this would also constitute police misconduct, so it would be investigated by, in the case of if it was a county police officer, but we know that they are not doing these violations, but it would be a police misconduct. And the idea here is not to set up any confrontation, but that's why I thought it might be complementary but to set up a recording of this. And the citation could be issued in a number of ways. It could be sent to ICE. It could be sent to the state's attorney. It could be sent to the county attorney, rather, who would enforce this. It doesn't have to be served like a court order and handed and physically handed to the ICE agent, for example. But I think we do want we want to make sure that we are recording these and that they are being taken into account, and if someone is in violation, that these citations there's a record of them, and that we know that they've been issued. So open to discussion on it, but that's the idea consistent with the state bill.
And to your point earlier, the amendment that I'm suggesting is about the portal, and I think we probably need to discuss it together.
Yes, I agree.
So that we can figure out what we do and don't have. My concern, and we're looking at, I guess, on Circle 26 at this point for my amendment. My concern is that if somebody decides, whether it be a police officer or whatever, they want to issue a citation, if they went over to a federal officer and said, here's a citation, first, a federal officer is not going to take it, but even if they did, is that considered impeding that federal officer at that point? I want to keep people safe. There are people that, horribly have been killed over these types of issues, and I want to keep people safe. So I don't know whether or not we should be confronting, I guess is the right term, in that type of situation, or whether we should do like what we've done for the Values Act. I always get it confused, Values Act. We've done enough of these, and that there be a portal, and that people can contact the county. They can take a picture. They can do whatever without confronting the time when it's actually taking place. And I do believe we need to change on mine that it wouldn't be it wouldn't go to the it would go to the Police Accountability Board rather than So anyhow, can we have those discussions, please? We're doing both together, please.
If we're talking about discussion here, that's fine, but I do want to say that when we talk about having an enforcement procedure, we'll have to pick one uniform process. And so, because each of them, what we should understand is that there's a due process point. So if someone is given a citation or is reported via the portal, we need to be very clear of what process they're using, if they're aggrieved by that, and then what's the next step. Now, if we're thinking about trying to merge them, we need to, so
it's
I just want
gotta
to
be
make
one
sure
or the
that
other.
it's one or the other and that we discuss them, pros and cons, one or the other.
Go ahead. Is anybody?
Yeah, I have thoughts, but I want to hear
Oh,
from you.
I'm sure you do.
So I I guess I would say, I mean, thinking this through, I was intrigued by the notion that Councilmember Jawando raised about being able to issue citations sans confrontment. I think I'm not sure, I'm not a lawyer, I'll probably going to say that a half dozen times before we're done today. But I don't know what the evidentiary threshold to issue a citation to an individual is, absent, as we've already discussed, they don't identify themselves readily. And so I'm not opposed conceptually, and certainly the executive would not be opposed to the concept of issuing citations. I don't know that ICE would pay them, but I think it's, I don't have a philosophical objection to the doing of it and the expression that we don't support their masking or failure to identify by themselves. But I'm thinking about this from an operational standpoint of how it would work and to whom would we be issuing the citation and what the evidentiary threshold. Would a picture be sufficient? For example, if we had a portal and we received pictures, could we issue a citation based on a picture without necessarily being able to say, is this HSI, is this ERO, is this the marshal's office, for example? I think that's the tricky thing, because none of those agencies are identifying themselves in the overt way that the Montgomery County Police Department is. And so I think I agree with Chair Katz that I'm concerned about the confrontation of an officer and an agent, and the way that the agent might respond by arresting our officers for impeding. And even if the charges don't hold, I don't want to put our officers in that position. I would not ask our officers to be put in that situation. And I also I have concerns about the public expecting that they'll be able to call 911 or the non-emergency line and have our patrol officers presumptively respond to a complaint of masking. In part because of the confrontment issue, but also in part because I don't want them deprioritizing other calls for service where we know there's someone in need of services, and we have at least uncertain or ambiguous authority to even issue the citation in the case of the masking in the first place. So I think I am definitely intrigued by, and I think the county executive would be supportive of the notion of being able to issue citations should we be able to meet the evidentiary threshold necessary to do those things, with the obvious caveat that I'm not confident at all ICE wouldn't just ignore them or rip them up or do whatever they would do with them. But I think the county executive would largely be supportive of the statement that we as Montgomery County do not support those kinds of practices in our county, even if it's of questionable enforceability.
Well, if we had the portal, and if it was correct that there was a violation of this, that we actually had authority for that, you could issue, whether it's a citation or whatever, to at that point. I mean, so it's not taking away from what.
Agreed.
Yeah.
Totally.
Yeah, well, and that's why he's saying it's complementary, but we're saying that we got to be a little bit more clear on this.
Ms. McCartney-Green may be able to fill in what the requirements for that class of violation are with regard to, whether a picture is sufficient to issue. I don't have the authority to issue citations myself. I've never gone through that training, but I obviously do know that there are elements of establishing a citation that you have to meet, and I'm not sure whether we would be able to meet them in these circumstances absent a confrontation with ICE. I'm just not certain about that.
We don't want the confrontation. As far as I'm concerned, nobody wants a confrontation.
So,
go ahead, please.
yeah, so I love Chair Katz's amendment because it captures the information. It captures that the things have happened. Where we are on very shaky footing is on any enforcement capability. And should what gets reported be permitted to allow the issuance of a civil citation, that's one thing. But absolutely, we can't have confrontations. We've got to be really, really clear with the public that we are not picking and choosing parts of the Constitution. Because I get it, everybody's trying to find a way to get to things and find a way to do something, but you can't tell our law enforcement officers, I expect you to follow the Constitution, and then ask them to issue citations to federal agents that they don't have the authority to do it to. Like, I don't understand how we get there when there's been so much vociferous argument about adherence to the Constitution and rights and understanding the balance of powers and how that plays into law enforcement. And asking our officers to violate the Constitution because right now it's a hot policy issue isn't appropriate. And I can't bless that. So, I'm happy for us to reconcile all these different pieces so that we do have a mechanism to report when someone perceives that they have viewed a federal agent masked operating in our community. But everybody has to level set the expectation of what that actually means in terms of a consequence. That's it.
Yeah, and I appreciate Councilmember Luke. We are lawyers, and this is a perfect example of lawyers can disagree all the time. And federal agents are not immune. They're only immune, let me phrase it this way, from state and local prosecution if their actions are deemed necessary and proper to carry out their duties. The very question in the California case is wearing a mask necessary and proper to carry out your duties? The language in what the judge said, the only federal court to speak on this said that is not, the mask is not required. But dismissed it or put a hold on it because of the discrimination between federal, state, and local. So I do think it's actually, and there are prosecutors around the country who are taking steps to charge ICE agents and federal agents. And so it's a qualified immunity. So I just want to say that, but I also agree 100%. I think there's 100% agreement on here. I'm not trying to create a confrontational moment here. You guys, that's not what we want, but we do want to capture the information, which is why I thought the portal could work with the enforcement mechanism. Ms. McCartney Green, I'm looking at you, because you capture the information similar to like a traffic enforcement camera or something, or, it's different, but same concept logically, that you get the information. It's also been observed by the officer. They're in court they physically observed it if they have a picture as well. And you don't have to create a confrontation. And that could be, we could track those citations. We could issue them. I'm sensitive to your point, Mr. Stoddard, that where would we send them? If we know, sometimes we'll know it's ICE. Sometimes we'll know, it could be broadly the Department of Homeland Security. But I mean, I do think there's a reason to track it and to have the visual evidence and information somewhere. And I don't think that would be inconsistent with issuing the citation without having to physically issue it. But we should check that. I agree with Councilmember Katz, but I know we issue citations without physically handing them to people in other ways.
Well, and then the question comes down to, and I think Dr. Stoddard mentioned earlier, first, if somebody's not wearing identification, how you know who it is? Right. If you take their picture and they're wearing a mask, it's even more difficult to figure out who they are. But there's a possibility that somebody might know them, or we could figure that out. Right. But I think the 100% agreement is that we do not want someone to confront and put themselves in harm's way in any way at all. So I think the portal, I think, is a way for us to get people that they can give us the information, they can get the information if they see something, and then at that point, once they report it, then whoever is looking at the portal will have to figure out what they can and can't do. So, and we would be tracking and we would have, what is actually taking place. So I'm comfortable with the portal.
Are you also comfortable with the issuance of a citation via the information gathered, that as long as it doesn't create a conflict? Because the state bill requires the issuance of a citation, and just to be back way up. So that will happen at some point, or will be the law at some point.
If I may here, Chair Katz, as everyone mentioned, when it comes to the amendment by Councilmember Katz concerning the reporting, that's what's captured there. The I that I have here says the information submitted through the online portal may be used by the Office of County Attorney to assist in enforcing county law and to make appropriate referrals to third parties, and we've mentioned Police Accountability Board.
And we're changing administrative charging.
Right, to police account,
yeah,
right.
Yeah.
This gives the discretion to the Office of County Attorney whether or not they issue a citation, whether or not it's dismissed, whatever it is, they have that, or they could make a referral as well. So there's a little bit more discretion here. in the approach by Councilmember Joando, it's aligning more with the state, where we are issuing a citation and going through an adjudication process. And so that's where I was saying that we have to figure out how do we want to start. Maybe the end result may be in the report, in the portal, but that discretion is up to the Office of County Attorney. What I've done here for Councilmember Joando is really just cite to our general enforcement procedure. Section 118 applies in various parts of the code, for various parts, where it gives the Office of County Attorney the option to proceed in that matter through a district court where there's appeal rights, where there's challenge. And so while it aligns with the state, it is a different approach. And so I just want to make sure we're clear on.
So is it your reading that under Councilmember Katz's amendment that there still could be the issuance of a citation?
Yes, the county attorney still, so section 118 stays regardless we're talking about federal,
Whether
state,
we-
or local,
yeah.
right? That's there
Okay,
and that's available.
Then I'm fine with that. Then.
Okay.
Yeah.
Are we good?
And I'll say, I have no issue with consulting with the county attorney's office, and we can talk about providing guidance as part of the portal aimed at collecting the necessary information that, should the county attorney believe citations could be issued under A, B, and C
Make sure we have
circumstances,
what we need.
we could steer the public into reporting in such a manner that would be consistent with that ability. Because obviously, as I said, I think the county executive would largely be supportive of it if it were, if we could meet the evidentiary threshold of a citation.
And when we talk about evidentiary threshold, I do want to be clear that state law does use the word probable cause. We don't have that under our code. So we may want to talk about what that is. And that's the reason why I did not mention that here in your amendment, Councilmember Joando.
Question, since in Chair Katz's amendment, it talks about the platform, but it doesn't talk about the standard, which you've just raised. Is that something where could we add that to make that clear so
Because
everyone's on the same page?
Because section 118 doesn't mention probable cause, I would need more guidance from the county attorney to make sure that maybe they are using that standard regardless.
Yeah.
But because it's not cited already in existing law, I'd like to get more guidance there before doing that here.
I think that would be helpful and to bring to full council so that, again, everybody's level set about what it is and how it works and what the standard is, since it's not already clear in county law.
And obviously, they're using some level of standard to issue a citation now under current authority. Yeah.
Assistant Chief Frank, did you have something to add on this, please?
No, I appreciate the conversation about creating the moment and not wanting our officers to be in that situation. I do see in the State Bill 1 where it says an officer may. But again, when you talk about establishing probable cause for our officers, they don't know what operation these federal officers are engaged in. They don't know the information they have, and now you're creating a moment, where you have this expectation we're going to have this officer write a citation to a federal agent that has no duty to identify themselves to the officer because they operate under different standards. So I do very much appreciate that conversation. The portal is a good idea and this is a very tricky issue. Like, what are you going to do to identify the person? Like, again, we talk about probable cause, identifying a person associated with issuing them some sort of civil citation. It gets very complex and murky, and that's why I do think I do like the discussion about the portal and figuring out what the Office of the County Attorney can do and follow up, and what procedures could you actually do if this was to occur.
Sounds good. Did you? Yes, please.
Appreciate the conversation and where we landed. And it's, we had similar conversations in regards to the County Values Act and discussion of the portal there. I think that this is landing in an appropriate place, understanding that we'll discuss in more detail at full council. But I think that I think that we're all aligned on the goals here. The intention is not to draw our local officers into a confrontation with federal officers. The goal is not to make community members think that is their best course of action when they see federal activity. And additionally, the goal is to attempt to find us a path to gain some leverage to enforce some kind of standards and some accountability over the actions of all law enforcement officers within our county bounds. And so I think that this strikes the right balance there, and with regards to the questions of constitutionality, in reading and Councilmember Jawando referenced this, but I think important to emphasize as well that what the judge found, the federal judge found, again, was that there in the decision that we're in a situation where the United States has not sufficiently made the case that the supremacy clause was relevant in regards to the mask ban and the identification requirement for the California law. And let's see, I'm going to read briefly from the decision. Although the challenge provisions dictate how a federal officer may carry out his law enforcement duties, prohibiting a facial covering and requiring the display of visible identification that includes their agency and either a name or badge number in non-exempted circumstances, the court finds them analogous to traffic laws that, in a similar sense, dictate how a federal officer may operate a vehicle on state roads, but are nonetheless enforceable against federal officers subject to immunities. And so, having read that, I am comfortable with what we're doing here.
Good.
Thank you.
Please.
I have a quick question, not about enforceability or anything else, but just because I need to know.
Wow.
What is meant by weather emergency or declared weather emergency? And the reason I'm asking that is because our department provides a lot of mutual aid to DC. So I'm aware that some of those events, particularly in recent times, have happened at really, really cold periods where they're there for like 10 hours, 8 hours outside working. And I get it. Those are in DC when we're providing mutual aid. But how do we determine declared weather emergency? And if it's not county declared, or if it's just below a certain temperature threshold, must there be a declared weather emergency? I'm trying to understand how to make sure for people who have to stand outside for hours and hours that they're allowed to wear what I might wear or what any of my colleagues might wear if we were stuck outside for those amount of hours, and understanding better what it means to have a declared weather emergency.
Assistant Chief, would you like to? You actually stood outside from time to time.
I did. I used to do those cert details for inaugurations and such, and they get very cold at 1 a.m.
Yeah.
What I will say, and I appreciate you bringing this up, there are some things in the exceptions that I do believe we need to discuss further and this is one of the things of waiting for the Training Commission to come up with a model policy, right? You have the time to think through things. My main goal is my officers are protected and don't do something inadvertently that normal people would do. So let's start with the declared weather emergency. I'm from Pennsylvania. 15 degrees is cold to me, and I might put a mask on, and I'm also silly too, and I might not. I've been on calls with officers when it's 35 degrees out, and they've got earmuffs and a face mask on because they are freezing, right? And that's just a comfort thing. They're not trying to do anything. They're not trying to keep their identity from anyone being known because, again, they're wearing patches and name tags and everything everywhere. So I don't want something in a temporary law until the new procedure comes out that would subject an officer to someone just being spiteful and saying, there was no declared weather emergency. You shouldn't have been wearing that. And again, if I point you to the Police Accountability Act, that would be an ACC qualified thing where someone would be reprimanded. The lowest form of reprimand would be a letter of reprimand. We have no way around that. That's the reality. It's not Darren going to his officer saying, hey, why were you wearing that? Well, the policy says declared weather emergency. So I think that needs to be just tweaked out some. There's some other conditions as an officer that you operate in that I don't want to see officers get. We can say, oh no, no one would ever complain and file a complaint against an officer. But how about when we have to medevac out people and the helicopter has to land in a dirt field and my officer puts a cover on their face because you got environmental contaminants, because the helicopter's kicking up, things like that. I can think of a number of things that I would just want to tweak out in these exceptions just to protect the officers. Again, I don't think anyone is trying to get our officers, but the reality is the situation we're in is people can get our officers because the system is that you make a complaint. If it's a violation of policy, and it's very clear, if it's a violation of policy, then it's considered misconduct. And I'd hate to say that an officer that was wearing a mask when it was 38 degrees out and a windstorm kicked up and someone filed something is involved in misconduct. So I would appreciate that we could just review that just a little bit to tweak it out some more.
So, I guess my question would be then, if I'm looking at subsection B5, which presently deals with exposure to cold during a declared weather emergency, and thank you for the helicopter example, because I hadn't thought about that, but it is really rough when they're landing, especially, when we here have experienced where we have no rain for like 6 weeks, and then it rains like a monsoon for 3 days. So is there a way to retool exception 5 to make it that are masks designed to protect officers in accordance with departmental policy, where you all allow them to wear them for personal protection in cases like that, where there's an environmental issue, there's a temperature issue? I mean, obviously, if I'm seeing an officer who's like in the middle of Rockville in August with earmuffs and a gator, that's going to raise a flag, and that's not
That's
real.
another kind of declared emergency.
Yeah, but obviously there are circumstances where temporarily or for long details, like the kinds I was talking about, where I know how miserable they are, where it's necessary. So is there a way for number 5 that it could be retooled to meet that and provide the right level of departmental discretion appropriate, while also making sure people know we don't mask routinely? Like, that is not a thing.
Can I note one thing? In the state law, there is an item 9. Any other item warrant to follow applicable laws of occupational health and safety or reasonable workplace accommodations.
Can we change number 5 to meet
I think
that?
what I would say about number 5 generally is,
Or add another
so
one?
the county does have a standard for cold.
Yeah.
We issue cold alerts when it is below 32, when you factor in the wind chill factor as well. And so you could leave that theoretically alone. I get because we do factor in wind chill factor when we issue those alerts. And so,
But that's a cold alert, not a weather emergency. Like,
yes,
the phraseology is different.
Yes, I do think we should accept that as a standard, because that's what we warn the public about.
Right.
We're warning the public
Right.
when those situations come from emergency management. I was involved in the development of this plan. It parallels DC's thresholds too.
Right.
And we could simply say, if it met the conditions of a cold alert in the jurisdiction in which the officer is operating, they would be reasonably allowed to wear a face covering in that case. And what I would suggest, and I think the county executive would say, is if you added a bullet 6 that just included the OSHA
Yeah.
and
I think that's
other
sufficient.
reasonable workplace, I think that would
Yep.
account for things because I think one of the things that we're going to see with this NPTSC is there are going to be situations that, like the helicopter example, none of us here have thought about,
No.
where we would be like, oh, okay, a reasonable person would wear a mask in that situation.
Right.
And what I might also suggest is there might also be certain situations where maybe they wore a mask, but then afterwards we reported back that they wore a mask for A, B, and C reasons. There could be a check and a balance here that was applied, where we think through, because I don't think we've never had an accusation that I'm aware of Montgomery County Police Department inappropriately wearing
Right.
masks.
Right.
I just don't want them to get into a tricky situation where something they would have been doing consistently for the last. I think the policy for uniforms goes back to 1999. That's the last time
Right.
that function code was updated. So it's been 27 years at this point, and we've been operating without complaints in that area. And I would just hate for us to create a circumstance where something that would have been totally normal to do 10 years ago and has been consistent with our policy, for which we've got no complaints, is now. Because Assistant Chief Frank is is correct. The ACC is not given latitude.
Right.
If it's a violation of policy, it's a violation of policy. And in that case, they don't get to say, well, it's a violation of policy, but we didn't view it as reasonable. We would view it as they don't get that discretion because it's meant to be uniform. You wouldn't want an ACC in a more conservative county saying, well, we don't think it's reasonable this policy, and we're going to ignore this
Right.
egregious behavior. So
Right.
they don't want the legislature did not give that discretion. So I think we need to be very cautious that we're not including anything that would inadvertently trigger a reportable and a punishable offense for an officer.
Yeah, and as you mentioned this, and as I mean, I know I made the joke about earmuffs in the summer, but I honestly started thinking about the level of gear and required stuff that I was required to send with my kid on a Scouts trip that did involve, they were thin gaiters. They weren't the kind to keep you warm, but they were the kind to protect you from the sun and from dust. Or our, we have summer air quality alerts where we are, told to stay indoors or what have you. And so there's a lot of flexibility in there. And by adding the exception that relates to OSHA, and as the state language captured it, I think we cure that problem in those types of scenarios.
Please. Go ahead.
I thank Earl for mentioning number 9 in the state law, because I also looked at that as well. The only difference between the council bill and the state bill is that the state bill requires for the police and training standards to develop this guidance, its policy, which will probably explain reasonable accommodation and what's probably accepted. In our bill, we're not deferring to regulations. This is usually something that I would say that would defer to regulations of what those reasonable accommodations would be. In this case, we're not necessarily doing that. And so just from a drafting perspective, what is reasonable accommodation workplace? What else should we be citing? So my only concern or is that the state law has that language, which I think is very, overly broad, which is fine. I have a good feeling that the policy may divulge into what that is and what's that acceptable. Under our bill, we're not giving delegation for regulations to be established to be able to establish some of those standards. And so that's the only thing, is that if we use that language, which I think is great language, we still open the door of what is reasonable workplace accommodation. Usually I try not to get too definitive or prescriptive in law, and I usually would have made the recommendation for regs, but I don't think that's the conversation here. And so just want to keep that in mind as we work through that.
I appreciate that. Yeah, and I think it's a balance to be struck here. We're trying to get this in place. And so going back to that, could you read that language one more time? That's in this, what is this, the state bill, the number 9?
Yep, I'm on the state bill. This is the amended bill, but Section 9 under the exceptions, under 3535 of the public safety article says, any other item warned to follow applicable laws on occupational health and safety or reasonable workplace accommodations.
Yeah. And so I think it could be the first part are laws, so that's clear. The second clause is reasonable workplace accommodations. That's where I think so I think of if you play this out, like if you're issued a citation for wearing a mask, there would have to be some burden of proof to say that it was a reasonable workplace accommodation. And you would have to say, well, we do this in this scenario, officers were wouldn't there be some sort of, but I get your point about the ACC. But in the determination of whether there's a violation, wouldn't the chief and the department have some discretion in that, with that phrasing? Because someone has to be the finder of fact of whether it was in a reasonable workplace
It would depend
accommodation.
whether our existing policy had, so if the existing policy has language that says deviations from this are acceptable under these circumstances or with these caveats, then you can. But if the policy says A, B, C, and D, then they're going to hold them to whatever the policy is. In this case, they'll hold them to whatever the law is. And so what I might suggest could be done here is, as I said, if a reasonable workplace accommodation is provided, the chief is required within X number of days to provide an explanation for said accommodation, and then that could be part of any review that
by the
ACC or whomever.
Would that help, Ms. McCartney-Green?
That would help. I just want to make sure we want that in law, or is that?
No, I think we need to put it in the law
Okay.
right now. Yeah.
Yeah, because I just don't want a situation where there isn't an avenue for, a circumstance that comes up in the field where AC Frank is overseeing an operation or one of the duty commanders, for example, and they make a determination, yeah, this is appropriate for you to wear a mask. They direct an officer to do so because of the unique situation that we just haven't conceived of in this.
Well,
work
even,
session.
and let's be clear, even the great wisdom of the Standards Commission at the state,
Yes.
they are not going to figure out every scenario either.
They'll have the benefit of time,
So,
but they won't think of everything either.
yeah, that's what I mean. That's
Yeah.
my point. So there's always going to be that, but let's try to close the hole as much as possible.
Especially for this.
Yeah, right now.
And just allow for those circumstances to be explained so that there's transparency with the public
Exactly.
about the
why
decision.
this was,
Right,
yeah.
right.
And so I'd be comfortable with that, given that it's not perfect, but I think given the instance that you brought up, I think I'd be comfortable with that, giving some discretion to the chief.
So Ms. McCartney Green, I feel sorry for you. Are you clear? Are you okay on
I didn't
that?
take notes this time, but I was listening, so I will. I'll rephrase it, and you guys can correct me. From my understanding, we'll make an amendment to the exceptions already provided in the bill to include any other item warned to follow applicable laws on concerning OSHA or reasonable workplace accommodation. The chief of police has the ability to, I'm going to use the word determine or make a determination whether it fits protocol that's consistent with this law. Something like that, I'm thinking.
I'm
Any
fine.
I'm
feedback?
fine with that.
My concern, and I'm going to always jump in just before her. My concern all along is what did declared mean? Who's declaring it?
Well, that was
Channel
emergency
4? I mean, how's that work?
Right.
Well, we do have a standard for a declared weather emergency.
Yeah.
So
I
we
appreciate
have
that, but who
we have
declared it? Yeah.
we have a sign. Well, declared weather emergency gets tricky because it typically requires more than just. We wouldn't declare necessarily an emergency for a cold day. It would have to be life-threateningly cold, which I believe is like 5 degrees or below. Which I would argue that there are thresholds above 5 degrees
Yeah.
where it would be
Yeah,
reasonable to
I've
wear a
heard
face
it's
covering.
hard, yeah.
Which is why we built the extreme temperature plan. Which the extreme temperature plan, we have 2 different thresholds. We have the higher level threshold, which basically warns the public that there's a cold weather coming, and then there's the higher level threshold, which triggers additional actions, particularly related to our homeless population, where we do extra things to bring them in. And we've done that because we want the public to be aware when there's going to be extreme cold, because we want outdoor workers to take additional steps. And obviously our police officers would qualify under the same conditions that a construction worker would outside, where we're telling them for your safety we should wear additional protection. And so that's what those 2 thresholds are meant to do. And I would argue that, those have been established. I mean, that plan was established, I think, in 2017 or 2018 when I was still at
So
emergency
do you think
management.
we should change this to that? Those
Yeah,
extreme
I think
as opposed to declared,
using,
you take that language out.
Yeah, correct. I think modifying it to be during events consistent with the county's extreme temperature plan or something
Great.
to that effect.
So that second clause. And then in addition to that, this other clause that we just talked about to capture the other.
I'm very comfortable
Okay,
with it.
thank you.
Please. You've been very patient.
That's what I'm known for.
Yeah, there you go.
I think that we've landed in a good place here, and I'll just say that I think it's important that we're not referencing a departmental policy, which would then put the the decision making power back into various hands, but rather we're referencing the county policy, which is clear to the public, clear to law enforcement officers, and something that is within our control and kind of consistent with how we're handling the rest of the bill. So I think that this landed in a good place. Thanks.
Okay. Anything else? One more thing. Yes, sir.
And I apologize for not putting this in my memo. I neglected to do it. The last amendment I would like is to have the bill be expedited. We're trying to fill the gap in time here, and that we did that with the Trust Act. So that would just, I think, Ms. McCartney Green, that wouldn't be too hard to draft. I think just that we would be changing this to an expedited bill.
Yeah, and I'm fine with that as well. Candidly, if it's not expedited, it'll be past, whatever the date is, it'll be past that. So, yeah. Go ahead, please.
The one other item that Assistant Chief Frank reminded me of, and it's something we had, I think, talked about on that, there are circumstances when undercover officers might, and I don't know that there's an exception that qualify, because they're not SWAT operators in that traditional sense, but they are part of undercover operations. Do you, I mean,
It says undercover.
sorry, I was giving a preview for the millions watching at home.
Didn't take us long to solve that.
I do want to roll back because we went into the exceptions, just so we're clear on the enforcement on the online reporting portal. That was a 3-0, correct? Okay.
Yes.
Okay. And then we had the exceptions, and then we had the expedited bill that was also 3-0 by the committee. Okay. So now we're moving on to bottom of page 6, is the clarifying amendments that Dr. Stoddard was referring to. One, the bill should define law enforcement officers. I realize that law enforcement agency that was there, but not law enforcement officers, and which basically means a sworn member of a law enforcement agency, and that defines federal, state, or local police. And then the second clarifying amendment was to make sure that this section does not apply to a law enforcement officer actively engaged in an undercover or covert operation. I actually looked up state law to find the definition of undercover. It's not there. They use the word covert. And so because there's many interpretation that what's covert was really is undercover. And so I've used both of them in that clarifying
I'm comfortable
amendment.
with that. Okay. It's where you get a 4-0 on any committee, I'm telling you.
That completes my questions
Go ahead,
or
please.
discussion.
Great, thank you. As we move forward with this, and thank you, everybody, it's a great conversation, important work, and I just wanted to, just to be really add some additional clarity on the constitutional questions, which I know we'll continue to discuss, not just in regards to this bill, but in regards to this federal government for us and for many others in the years to come here. But again, from the federal judge's decision, quote, finally, the threat of prosecution facing federal officers for a violation of state law cannot be a cognizable interference with federal operations. If that were the case, then no state law would be enforceable against federal employees exercising their federal duties. But the law is clear that federal officers do not have absolute immunity from state prosecution. Supremacy Clause immunity thus ensures a constitutional balance of state and federal powers without requiring the facial invalidation of state laws that incidentally affect the federal government. And I think it's under these actions that we're moving this forward, and appreciate it. Thank you.
Okay. Yeah, go ahead.
It's just a word of thanks to the committee and to the public, and I know there's some advocates here in the room. Thank you for your work, and thank you to our police department. I just want to emphasize that I know you have a difficult moment right now. You all are not the reason that this bill is here. It's because of the unlawful actions of our federal law enforcement, particularly ICE and CIS, and I'm glad we're going to move this forward to the full council, and I want to thank Ms. McCartney Green again for her just work on this bill, and all my staff, Marisa, who's in the audience as well, and glad this is looking like it's going to move to full council. Thank you, Chair Katz.
Thank you very much. So it is a 3-0, yes? Yes? 3-0. Thank you very much. Anything else, Ms. McCormick? I'm sure you're going to be just tickled not to have anything else on this.
I'm waiting.
All right, thank you. We are adjourned. All right.